tribal consultation, currently as it stands, is this process in which the federal government is required on a nation-to-nation basis consult with tribes. The tribe in Standing Rock is saying that didn't happen. They are saying that the consultation was pretty minimal with the federal government, and even if it had been picture perfect and they had met every single requirement they were supposed to meet, I would say that's still not enough. Because tribal consultation in this country, as it stands, means that you can go to every single meeting, you can have every interaction with the federal government, and they can still say, we're doing this project regardless. That's not free and informed consent. Free and informed consent should be the standard. That should be what's implemented in this country. That's what the UN Declaration on the Rights of Indigenous People mandates. That's what we should be following. An environmental impact statement is something that should have been done on the Dakota Access Project. It's actually what the tribe is suing the Army Corps of Engineers about. An environmental impact statement is like this massive environmental review that typically takes anywhere from 1 to 2 years, can take longer, in which they have to consider cumulative impacts. They have to actually look at, how is this going to affect the water quality? How is it going to affect air quality? Is this going to impact cultural and sacred sites? And in the case of Dakota Access, there's sacred places all over in that pipeline route. I just spoke with one of the women that was LaDonna Allard. She's one of the matriarchs of this movement and is from Standing Rock and was at the Tribal Historic Preservation Office. She knows these places. Her family knows these places. And she said where it's at right now, to put it in context, that the pipeline has about 5.5 miles, as of today, 5.5 miles of untouched land left before it hits the Missouri River. That's how close it is. The message is still going out that construction has stopped. It has not stopped. It has increased. The court ordered, so-called buffer zone on either side of the river was lifted, and the company is now throwing that pipe in as fast as it possibly can to get to the river. The one, the saving grace is that, we have this Army Corps permit under the river that needs to be issued for them to actually go and drill their pipeline under the river. And that's where the tribe is saying you need to do an environmental impact statement. Because if you did an environmental impact statement, this project wouldn't be approved. It would have never been approved. This thing in EIS is the gold standard instead of an EA, which is an environmental assessment. That's the lowest level environmental review. That was what was done with Dakota Access. The company used a loophole, Nationwide Permit 12. They're these general permits that are typically for boat ramps and small-scale water projects, and chopped up the pipeline into thousands of little pieces, into thousands of little crossings, and said this is just a small-scale infrastructure project. You don't have to consider cumulative impacts, and that's how the government looked at it. That's how the government got that project through, is through use of Nationwide Permit 12. So, yeah, it's a complete violation of the intent of the National Environmental Policy Act. It's a complete violation of the intent of the National Historic Preservation Act. These are policies and federal statutes that were put in place to protect the environment for the people. They're viewed as, by these profiteering industries and by a lot of our conservative members of Congress, as roadblocks to more jobs and more economy and more money. And that's absolutely not true. I mean, these are protections that are put in place for basic levels of review that you should be doing for a fracked oil pipeline that's almost 1,200 miles long, going through so many rivers and going through so many communities and people's homes. I mean, these are basic things. These requirements should be more stringent. That's the reality, and unfortunately we have a Congress that continues to deregulate these statutes, these regulations. It was very disappointing. I actually sat in a meeting with the Army Corps of Engineers, and the actual representative of the Army Corps of Engineers couldn't describe the permitting process because it had been so deregulated for oil specifically that he didn't know why there was a 14-day notification process once the permit's granted. He didn't know what the actual process was because it's been so deregulated. It's very important to participate in the process because they're controlling the process right now. They're controlling the conversation, and it doesn't include our interests. And that has to change.